Hi, this is snc-lavalin case group. My name is Yizhou Xiao.
My name is Qingyang Zhang.
My name is Yilin Zhang.
Okay, so we're gonna introduce the snc-lavalin case. Now, first I'm gonna introduce the background and the key relevance. Next page, please. So, SNC is a major Canadian engineering firm facing criminal and corruption charges. The charge alleged that between 2001 and 2011, snc-lavalin and two of its subsidiaries paid 48 million Canadian dollars in bribes to officials of the government in Libya. They also alleged that the company also defrauded Libyan organizations out of 130 million Canadian dollars. If convicted, the company could not receive federal contracts for 10 years, which could lead to a significant job losses and even bankruptcy. Next page, please. And after charges were laid against the snc-lavalin in October 2017, the company engaged with officials in Ottawa, including members of the Prime Minister's office, to secure a DPA. This would have allowed them to avoid a criminal conviction. Jody Wilson-Raybould, the Canadian Attorney General, has the power to override the decision of Kathleen Roselle, who in October 2018 denied the DPA request. However, any such directive must be issued in writing and published in the Canadian Gazette. On February 7th, 2019, the Globe and Mail reported that the Prime Minister's office under Justin Trudeau pressured Wilson-Raybould to intervene in criminal proceeding against the snc-lavalin and to push for a DPA. Wilson-Raybould reportedly refused the request. Based on a 1959 statement by Lord Shawcross, the statement outlined the parameters that the Attorney General could and could not consider in making his decision. The doctrine provided that the Attorney General must consider matters of public interest, that the assistance of cabinet colleagues must be limited to the provision of advice. The responsibility for decision rested with the Attorney General alone, and the government must not exert pressure on the Attorney General. She provided details and dates of the meetings and named the 11 individuals involved in the alleged intervention, including Trudeau, Vernick, Grenade Butts, etc. In a cabinet reshuffle on January 14, 2019, Wilson-Raybould was moved from the position of Attorney General to the Department of Victorian Affairs. The move was seen by many as a demotion, leading to speculation as to why. Wilson-Raybould released a recorded phone call with Vernick in which he mentioned that Trudeau wanted a DPA for snc-lavalin. Somehow, Ethics Commissioner Mario Dion launched an investigation into the interference allegations. Opposition parties, the media, and the public reacted strongly, with some calling for Trudeau's resignation and others calling for a thorough investigation. On April 2nd, 2019, despite attempts to convince her to reconsider her position due to the potential economic and political consequences, Wilson-Raybould said that she has no hesitation in sticking to her position and does not seek to delay the prosecution agreement. Trudeau expelled Wilson-Raybould and Jane Philpott from the Liberal caucus. Next, pass it to Qingyang Zhang.
Okay. So, we are going to identify the core ethical dilemma. So I'm gonna raise the dilemma questions. Should political and economic considerations influence legal and prosecutorial decisions, especially when significant economic consequences and potential job losses are at stake? So we're gonna explain both sides of the dilemma. Okay, we come to the next page. Yeah, next page. The dilemma perspectives had two sides. The first side is favoring political and economic considerations, and the second side is to favoring independence of legal and prosecutorial decisions. Well, each side has their own advantage and disadvantages, and I will talk it specifically in the next page. Okay, come to next page. So first, we're gonna discuss the side A, favoring political and economic considerations, and we discuss its advantages. It has economic stability, which means protecting major companies like snc-lavalin from severe legal penalties can prevent potential economic downturns, safeguarding jobs and ensuring economic stability. Well, as highlighted in this case, a criminal verdict against snc-lavalin could lead to the company being barred from federal contracts for 10 years, potentially resulting in its bankruptcy and significant job losses. Well, we come to the political stabilities. The government might be seen as proactive and protective of national interest, potentially gaining public support. The pressure from the Prime Minister's office on Jody Wilson-Raybould can be viewed in this light as an attempt to safeguard national economic interest. Well, we come to the final public interest. So that means in some views, the broader public interest might be served by protecting major employees from severe legal penalties, especially if the alternative is economic disruption. Well, we come to the disadvantage side of it. It has erosion of the trust. Firstly, the case brought to the light allegations of undue pressure, leading to public debates and potential erosion of trust in the government. Such interventions can be erode public trust in the government, leading to executions of favorism or corruption, and the legal precedents. Intervening the legal decision based on economic and political considerations can set a dangerous precedent, potentially undermining the rule of law in future cases. Okay, so the side B is favoring independence of legal and prosecutorial decisions. The advantage of it is like upholding rule of law. Wilson-Raybould stand on not overwhelming the director of public prosecution decisions. Underscore this principle. It ensures the legal decisions are made independently of political pressure, upholds the rule of law, a foundation principle of the democratic societies. And it also has the public trust decisions. Independent prosecutorial decisions can be bolster public trust in the justice system. It ensures the decisions are made based on legal merits and not external pressures. Well, when we discuss about the disadvantage side of it, we have economic repercussions. In this case of snc-lavalin, the potential implication of a criminal conviction were significant, including potential bankruptcy. We discussed about political fallout. Discussions are not taking into account broader political and economic considerations can lead to a political fallout, which government be seen as not protective of national interest. Well, so we come to the next page and it's Leo's part.
Okay, at this part, we're going to talk about the ethical theories in play. First, for the deontological ethics. From a deontological perspective, governments have a responsibility to maintain the rule of law and the integrity of institutions. Interference in the judicial process based on economic considerations would be considered unethical. And the next part is about the virtual ethics. From this perspective, the focus is on the character of the decision maker. Ethical leaders should exhibit virtues such as integrity, honesty, and fairness. If the government acts out of the political considerations or the desire to protect business at the expense of more moral and legal standards, then this would be seen as a failure of virtual ethics. And the last part is about the utilitarianism. From the utilitarian perspective, the government may argue that intervening on behalf of snc-lavalin will serve the greatest good of the greatest number of people. or preserving jobs and economic stability. However, such an approach may ignore the long-term harms of undermining public trust in the justice system. And in conclusion, the snc-lavalin case presents a complex ethical dilemma involving a balance between economic considerations and the rule of law. Various ethical theories and the tests provide different perspective to evaluate the government's behavior and the decision-making in this case.
That is everything for our presentation. Thanks for listening.